start my video.
Well,
Yes.
I can't see you right now. You
All
can turn
right.
on.
How
There we
about
go.
now?
Okay, so who else is appearing with you, Mr. Cervantes, for the prosecution team?
I believe it's going to be Ken Petrozelli.
Okay, so Mr. Petrozelli, I see you listed here. Can you unmute and turn on your video?
So I am unmuted and I only have the option to stop my video. So does that mean my video is on?
Well, we can't see you yet, so I've
Yeah, I can't see myself either, so I don't.
So Ken, the button right next to mute on the lower left-hand bar, click that. It says stop video, but yours should say start video. See what happens there.
I'm still not seeing myself.
Have you checked the little lens cap? At least on my computer, there's a lens cap you have to switch on.
It's open.
Okay. You're listed as your video is on here, but we can't see you.
Yeah.
Also, you might, if you can, on the volume, turn up your volume a little bit. It's kind of hard to hear you.
Okay.
And we've got plenty of time, so
Okay.
don't worry. I don't think we've ever had one of these meetings go without a few technical issues. Well, while Mr. Petrozelli is working on that, Mr. Cervantes, is anybody else going to be appearing this afternoon for the prosecution team?
I don't believe so. I think it's just going to be Ken and I.
Okay. All right. And if somebody else needs to speak up, that's fine. So the next question is anybody here for Timberlake Estates Homeowners Association? If so, please speak up, and if you can, also turn on your video.
Hi, this is Debbie Schaefer. I'm representing Timberlake Estates.
Okay, good afternoon, Ms. Schaefer. And okay, on my computer, yours just shows up as home laptop, so that's fine. I just wanted to make sure I knew who you were on the screen here, but good afternoon. And
Hi.
will anybody else be appearing for Timberlake Estates Homeowners this afternoon?
No, just me.
Okay. All right, well, stand by. It looks like we're still having some challenges with Mr. Petrozelli. We could hear him, but not see him.
So hearing officer Lilly, I think we may have Patrick Lewis as well on the prosecution team.
Yeah.
Okay, I see that he is here. Mr. Lewis, would you like to unmute and turn on your video? There you are.
Good afternoon, Hearing Officer Lilly.
Yeah, and you can just call me Mr. Lilly. It's a lot easier. We're going to get to that. But
Thank you, Mr.
hearing
Lilly.
officer takes too many words. So, okay, well, Mr. Petrozelli, can you hear us? And let me just see if we can still hear you.
I can hear you. I can hear you just fine.
Okay, and we can hear you just fine too.
Yeah.
So it's up to you. Do you want to spend a couple more minutes trying to figure out about your video, or do you want us to just go ahead with you on audio only?
You know what? Go ahead. Yeah, just go ahead. You know, we practiced and we figured everything out, but I don't know what's happening today. So.
Yeah, and I'm sorry, but I don't either. Can you see us?
I can see you.
Okay, the most important thing is then you'll be able to see exhibits when they're
Yes.
put on the screen. So, okay, well, I'll tell you what, we'll just give you another minute or two to see if, I mean, I have no idea what to do because you're listed as your camera is on our on my listing here of participants. So I don't think it's us. I think it's something with your computer.
Yeah, so let me try leaving the meeting and then rejoining.
Okay, we'll just take a pause for a couple of minutes
Okay.
while you do that. Okay, Mr. Petrozelli has definitely left. Hopefully he can get back. Okay, he is now waiting. I'll see if I can admit him. I clicked on admit, it says joining. Okay, so Mr. Petrozelli, I see your icon. Can you speak now? Oh boy, we may have lost. No, he's still, boy,
I just
wait,
joined.
now I can't hear you at all if you're trying to speak.
I barely heard him.
Yeah, I
Do you
could
hear
hear
me?
him also.
Okay, I do know one trick, Mr. Petrozelli, is if you click on the mute icon, just to the right of it, there's a little arrow that should give you a volume control.
Okay, how is this?
Oh, perfect.
We can hear you great.
Okay.
I guess we're going to just have to proceed without seeing you. Can you see us now?
I can see all of you.
Okay. Well, if that's okay with you, and we do have Mr. Lewis also representing the prosecution team, and you know, and you'll certainly be able to participate. So if that's okay with you, I suggest we proceed. Is that acceptable?
Yes.
Okay. And I don't think I've done a Zoom meeting yet where we didn't have some technical issues, so we'll keep going forward. So, first of all, by way of introductions, my name is Alan Lilly, and I am the presiding hearing officer for the State Water Board's new Administrative Hearings Office. This hearing is being conducted by the Administrative Hearings Office on the administrative civil liability complaint that the State Water Board's Division of Water Rights Assistant Deputy Director Julie Rizzardo filed on July 1 of last year, 2019, against Timberlake Estates Homeowners Association. And so just by way of shorthand, when I say AHO, I'm referring to the Administrative Hearings Office, and when I say ACL, I'm referring to the administrative civil liability, as in the ACL complaint. Assisting me today, and you'll see them on the listing, they may or may not need to say anything depending on how technically proficient I am, are Skylar Anderson, Kyle Woldridge, and Nicole Mullen from the AHO. And we also have Amy Blank from the Division of Water Rights and Carol Berkeley from the Office of Counsel. We have people because it's the first time we've done a hearing, and we wanted to make sure we don't have any technical problems. So please be patient as we go through this. And the display is working well with all the participants, Mr. Cervantes, Ms. Schaefer, Mr. Lewis, and Mr. Petrozelli all at the top of my display, at least right now, until we go into a different format. So that's good. And certainly, if anybody gets cut off, we will pause and make sure we get the person back on so everyone can participate. So we've covered appearances. Let me just check my notes. And as I mentioned to everyone else, it looks like all the rest of you are muted. So unless anybody else needs to speak, we'll keep it that way. Certainly, you don't even need to identify yourself, although many of you have. And this is a public hearing, and anybody who is interested may listen in, so that is fine. I will just check and see if we did in the hearing notice have an opportunity for people to present policy statements. I didn't see anything submitted in writing, but if anybody, is there anybody who wants to submit a policy statement? If you can, I believe there's a way you can raise your hand virtually and we'll see it on the list. So I'll just sort of check the list here and see if anybody else is interested in speaking. I'm not seeing anybody now, and if for some reason that comes up, we can certainly take a person out of order if we have to. So let me just go over the process. Obviously, it's a little tricky doing this all by teleconference, but I think we're all getting better at these teleconferences as we move forward. I will call on people to speak. I do ask you if you can put yourself on mute when you're not talking. It can reduce feedback problems. Although right now I'm not having any problems. But and then if you start speaking, we can't hear you. We will let you know you have to unmute. That certainly is something I've forgotten about a few times. And if you, I believe there's a way you can raise your hand if you need to speak. But hopefully with just two parties, it won't be too complicated. So as I mentioned earlier, please just refer to me as Mr. Lilly, and I will refer to each of you as Mr. with your name or Miss with your name. This is not a court proceeding, so please do not say Your Honor or anything else. But I do want to use Mr. and Ms. to keep the proceedings a little bit formal, and let's try to avoid, at least in the formal proceedings, referring to each other by first name. Certainly when you're referring to your colleagues, you can refer to them by first names, and that's fine. And if I don't think it's going to be a problem, I think it's be pretty clear who's speaking, but if there's any confusion and I say, ask you to identify yourself, it's probably just because I want to make sure the record is clear. I will ask Nicole and my staff, Nicole Mullen, to put each exhibit up on the display as it's being discussed, and we'll have to see how that works. We were practicing it a couple of days ago, and it seemed to work fine. But if anytime you want us to put up a different exhibit, whether it's your exhibit, one of yours, or one of the other parties' exhibits, please let us know, and we'll take a pause and make sure to get the right exhibit up on the screen. This, as I say, we're all learning, so please all be patient as we go forward. We are recording this proceeding electronically, and our plan after the meeting is to post a video plus audio file of the proceeding, and then also a separate audio only file on our FTP site. So any of you who want to can go back and either listen to that or watch that and see about the proceedings. We do not have a court reporter. We're just relying on the Zoom recording. So, and then just by way of process, because the prosecution team has the burden of proof, the burden of proving its case in this hearing, the prosecution team will go first. And before the looks like just one witness testifies, I will administer the oath. And then after the prosecution team has presented its witnesses, a representative of the respondent, and that I guess will be you, Ms. Schaefer, may ask the prosecution team any cross-examination questions that you want to. But you do not have to ask any questions. That's just your option. And I do want to emphasize there are two different parts in the proceeding. First, Ms. Schaefer, you will get to ask Mr. Cervantes cross-examination questions, and then after he's done testifying, then I will give you the oath, and then you will get to testify. So sometimes it's a little confusing, but do try to split it up into the first part is your questions for him, if you have any, and then don't worry, you will get a chance to testify as well. And Mr. Petrozelli, I'm happy to say that you are on the screen, but I'm sad to say you're upside down. And I don't know if there's anything you can do about that.
Oh, there it goes.
All right. So now we have Mr. Petrozelli on video only. Whatever you did it right. And thank you.
I have no idea what I did.
Yeah, we won't ask. Sometimes there's some mysteries with the computers. All right. So, and then as we go forward with Ms. Schaefer, after you testify, the prosecution team may ask you questions on cross-examination if they want to. And then we can go through rebuttal. If anyone has any responses to the other side's, other parties' exhibits or testimony they want to present, they can do that. And then finally, I will allow brief closing arguments, which are not testimony or questions, but just an argument if there's anything anyone else wants to say. After that, the matter will be deemed submitted to my office, and by law, under the Water Code, we will have 90 days to prepare a proposed order. And I hope we can do it faster than that. And then as discussed in the hearing notice, our proposed order is under Water Code section 1114 subdivision C. And under those statutes, we transmit the proposed order to the clerk of the board for consideration by the 5 board members. When we do that transmittal, we obviously will transmit copies of the proposed order to both parties' representatives and also to anyone else who is signed up to receive AHO emails, and we'll post it on our webpage. So it should be available for anybody to look at who wants to. So before we go forward, does anybody have any questions? And I'll start with you, Mr. Lewis and Mr. Petruzzelli. Do you have any questions about this process?
So I think the only question I had is that while testimony is being provided, it's important to ensure that anybody who may potentially be making objections has the ability to unmute their microphone to make objections timely. So
Okay, and
perhaps
that's
already-
certainly a very valid point. So what we'll do is we'll make sure that during the testimony, we won't mute any of the four people, Mr. Cervantes, Ms. Schaefer, Mr. Lewis, or Mr. Petruzzelli. We will keep all of you off mute. You can decide. I mean, frankly, there's no problem with feedback right now with any of you. So if you want to stay off mute, so you can object if you need to, that's fine. Or you can just click on that. But it's a good point. And that, for Ms. Schaefer as well, if you think that one of Mr. Petruzzelli or Mr. Lewis's questions is improper, just speak up with your objection, and I'll certainly listen to that and issue a ruling on that. Okay, any other procedural questions for the prosecution team before we get started?
No, Mr. Lilly.
All right, thank you. And then Ms. Schaefer, if you can just go off mute and let me know if you have any questions about the process.
Not so far.
Okay, and I understand it's maybe a little overwhelming, which if you're not an attorney, to have to go through a procedure like this, which involves a lot of legal things. So we'll certainly proceed carefully. And if you have any questions about the process as we go forward, please just let me know and we'll pause and try to address them. We certainly want this to be a fair process and for everyone to be able to have a chance to present their evidence and be heard. Okay, so with that, Mr. Cervantes, I'm going to start. I see you're over here. First of all, I do have to give you the oath to testify. So do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. And then Mr. Lewis or Mr. Petruzzelli, you may proceed, and please ask us if you want us to put any of the prosecution team exhibits up on the screen while you are asking Mr. Cervantes questions.
So Mr. Lilly, Mr. Cervantes does have a PowerPoint presentation that he will be sharing. Yes.
Okay, we did that. You submitted that last week, and we posted it on the FTP site, and we labeled that exhibit PT10. So we'll see if Nicole can get that exhibit PT10 up on the screen right now, and if you can just bear with us for a minute.
So Mr. Lilly, if it's all the same, I can share my screen. If whoever is administering this Zoom enables me to share my screen, I can just control the slideshow myself, and that would probably be easiest.
Okay, we would prefer to put our copies of the exhibits up, because if we can, just because those are the ones that are actually in the record. So we'll do it this way, and I'm sorry if I'm a control freak or something here, but just let us know and we'll go forward from page to page as necessary. So we've got it on full screen here on the first page, and with that, you may proceed. And I don't know whether it's Mr. Lewis or Mr. Petruzzelli who's ever asking questions. Please proceed, and either just let us know if we're on the wrong slide and we'll adjust.
Okay. So Mr. Lewis, please begin your testimony.
I assume you mean Mr. Cervantes.
Mr. Cervantes,
Yes,
please begin your
okay.
testimony.
Excellent, thank you. Okay, so I'll call out the slides, or the person who's administering the slideshow. I'll just call out what slide I'm on. So right now, let's start with slide 1. Good afternoon, Mr. Lilly. My name is Robert Cervantes. My testimony today supports the State Water Resources Control Board Division of Water Rights recommendation to issue an administrative civil liability order against the respondent, the Timberlake Estate Homeowners Association. I'm the program manager of the Water Rights Enforcement Section and a licensed professional civil engineer. I have over 18 years of technical and regulatory experience related to water resources issues. I have been in the Water Rights Enforcement Program. I've been the Water Rights Enforcement Program Manager for 10 months. Slide 2, please. The California Code of Regulations, Section 929, requires water right license holders to submit annual water diversion and use reports for each year's diversion and use. We call them annual reports for short. Annual reports must be filed electronically by April 1st using our online report management system. Failure to file an annual report by April 1st violates the regulation and the terms of the respondent's water right license. Information included in the annual report is critical for administering water rights and managing the state's water resources. Timely submission of this information allows the State Water Board and the public to know when, where, and how water is used, plan for drought, and ensure water is being put to beneficial use. The failure to file enforcement program helps ensure that diverters provide this information through a progressive enforcement strategy using education, outreach, and if necessary, formal enforcement. Slide 3, please. ERIMS identifies the respondent as the primary owner of water right license 7716. The respondent was required to file an annual report pursuant to Section 929 of the regulations. The respondent failed to file the annual report by the deadline, violating the regulation and license terms. Ultimately, after extensive outreach and an ACL complaint, the respondent filed the annual report on July 7, 2019, 97 days after the deadline. Slide 4, please. This is Prosecution Team Exhibit 3, the ERIMS database query for Timberlake Estates license and ownership. It shows the respondent has been the primary license owner of 7716 since December 12, 1995. Slide 5, please. This is Prosecution Team Exhibit 8, an ERIMS database query showing the dates the respondent has filed annual reports. Personal identifying information is redacted. The query shows the respondent filed the 2018 annual report on July 7, 2019. Slide 6, please. The Division of Water Rights Enforcement section ensures that the regulated community complies with water right laws and regulations. The purpose of the failure to file enforcement program is to achieve this goal for annual reporting through compliance assistance and progressive enforcement. The next 2 slides describe some of the division's work to notify the regulated community of the requirement to file annual reports, assistance in fulfilling the requirement, and outreach to compel compliance after the reporting deadline. Slide 7, please. The enforcement section and the data management unit started collaborating early January 2019 to notify the regulated community of the reporting requirement and provide compliance assistance. Staff hosted a water measurement workshop on January 18, 2019, to give the regulated community an opportunity to ask questions and file reports in person. In addition, staff mailed letters to primary license holders and agents regarding the pending April 1st filing deadline. This is Prosecution Team Exhibit 1, a copy of the February 15, 2019 letter mailed to the respondent at the address of record associated with the water right license in ERIMS. This letter informed the respondent of the requirement to file the annual report by the April 1st deadline, provided instruction on how to file the annual report, and warned of potential penalties if the annual report was not filed by the deadline. Before the April 1st deadline, division staff provided additional notices concerning the filing deadline using the State Water Board's Twitter account. Between March 13, 2019 and March 29, 2019, 7 separate reminders were posted. Slide 8, please. After filing the deadline to submit annual reports passed, division staff monitored ERIMs for compliance and issued notices to the primary owner or agents for water right licenses that failed to file annual reports. These notices included a postcard, a deficiency letter, and social media outreach. The postcard, Prosecution Team Exhibit 4, was mailed to the respondent's address of record, notified the respondent of the failure to file the annual report, and offered reporting assistance. The notice of deficiency, Prosecution Team Exhibit 6, was a final warning and mailed to the respondent's address of record. This June 12, 2019 letter notified the respondent that the annual report was still deficient, explained that the division was prepared to issue an administrative civil liability complaint, or an ACLC, for the respondent's failure to file, and provided instructions on how the respondent could avoid any potential penalty. In an attempt to encourage voluntary compliance, staff posted a tweet to the State Water Board's Twitter account on June 27, 2019, informing all water right license holders with deficient annual reports that the division would issue ACLCs soon on all outstanding annual reports. Slide 9, please. On July 1, 2019, with the respondent's annual report still deficient, and despite extensive outreach, division staff issued an ACLC to the respondent for their violation of Section 929 of the California Code of Regulations and the terms of the respondent's water right license, with a recommended penalty of $2,000. Slide 10, please. In determining the proposed penalty pursuant to Water Code Section 1055.3, the prosecution team considered the harm caused by the violation, the nature and persistence of the violation, the duration of the violation, the respondent's corrective actions, and all other relevant circumstances. I'll discuss each of these factors in turn. First, let's start with harm caused by the violation. The respondent's violation harms the orderly and efficient administration of the state's water resources. This in turn impacts other water right diverters, the environment, and the public at large. As previously mentioned, the information the regulated community includes in the annual reports is critical for administering water rights and managing water supply. Without clear and timely understanding of who is using water, how much is being diverted, and when that water is being diverted, the State Water Board is limited in its ability to perform the following 7 essential functions. First, issue accurate permits or grant petitions. Second, determine availability of water and likelihood a diversion may cause harm. Third, conduct a timely and accurate billing for water use. Fourth, conduct a fair, efficient, and accurate drought management. Fifth, develop in-stream flow requirements and protect public trust resources. Sixth, build and calibrate water resource planning models. And seventh, last but not least, respond to and evaluate complaints of alleged illegal diversions. On an aggregate basis, these types of water rights violations undermine the validity and transparency of the water rights system. Now let's talk about nature and persistence of the violation. As detailed in this presentation, the division conducted extensive compliance assistance and outreach to the regulated community to ensure compliance with reporting requirements. This included workshops, email reminders, letter reminders, tweets, failure to file notices, notices of deficiency, and warnings of imminent ACLCs. Notwithstanding, respondent failed to rectify their failure to file its deficient annual report. It was only after significant resources were expended in an effort to compel compliance that an ACLC was issued. Now let's talk about duration of the violation. The value of the data and information included in the annual report for inclusion in water availability forecasting is diminished when not obtained timely. As such, every annual report that is not filed by the deadline contributes to water resource modeling uncertainty and inaccuracy. Moreover, the length of time over which respondents' violation persisted despite repeated attempts to notice the failure to file is significant. Let's talk about the diverter's corrective action. On July 7th, 2019, the respondent filed the deficient annual report. This is 6 days after the division issued the ACLC. Considering the extensive outreach performed by division staff to compel compliance, respondents' late filing, greater than 90 days after the deadline, is not a reasonable and prudent response to the violation. As such, the respondent's corrective action does not merit a reduction in the proposed penalty. Next, let's talk about other considerations. As part of the division's progressive enforcement strategy, the respondent was encouraged to settle the alleged violation. The division proposed a 3-part settlement offer to the respondent. This included paying a reduced liability, $500 per reporting violation, filing the delinquent report, and signing a waiver of the right to hearing. This settlement amount represents 1 day of violation and a 99% discount the potential maximum liability the respondent may incur for the violation. The settlement amount is low enough to encourage voluntary corrective action, but still high enough to encourage voluntary compliance in the future. The respondent rejected this offer. In contrast, the proposed penalty, $2,000, represents 4 days of violation. The exact costs of the failure to file enforcement program were not analyzed. However, over the course of 11 months, an estimated 286 staff hours were required to conduct outreach, monitor voluntary compliance, and compel compliance with the reporting requirements. The division believes the proposed penalty is the minimum amount suitable to deter future non-compliance, while accounting for the resources spent by the State Water Board staff compelling the diverter to file the requisite annual report. We further believe it is the minimum amount that encourages voluntary compliance through the settlement offer. Thank you for your time. I'm now open to questions.
All right, thank you, Mr. Cervantes. Ms. Schaefer, as I said earlier, you don't have to ask any questions of Mr. Cervantes, but you may if you want to. And then just to clarify, this is separate. You will have a chance to testify, to state any facts or other arguments you would like to make. But right now, I'm giving you the opportunity to ask Mr. Cervantes any questions. So please unmute yourself and then let me know if you want to ask him any questions.
Before we go to cross-examination, I wanted to ask Robert one thing.
Oh, excuse me, Mr. Petrozelli. I should have given you a chance. I thought he said he was finished. So, but
he did.
Excuse me, Ms. Schaefer. Mr. Petrozelli does get to ask Mr. Cervantes a follow-up question first, and then we will shift to you.
He said he was open to questions, but he didn't necessarily exclude me. So, Mr. Cervantes, if you could go to Prosecution Team Exhibit 8.
Okay.
Or
I'm actually not
the hearing
controlling
officer could.
slides.
We'll get, hold on, we'll get Prosecution Team 8 up. Just, you want the Exhibit PT8, not
Yes,
Slide 8,
please.
right? Okay, hang on, we'll get it.
I think that'll be easier to see.
Just give us a moment. Okay, just bear with us. We're getting there. I think. Okay, we now have PT8 up on the screen. I think it's just going to full screen. And let us know, Nicole, it might be good if you could enlarge that. I assume it's mainly the top part that we wanted to see. So probably a little bigger will be easier for us to see if you can. If it'll let you zoom it out, maybe it won't. Okay, well, anyway, Mr. Petroselli, go ahead. Okay, there we go. That's a little better. Go ahead.
So, Mr. Cervantes, I'd like you to look over this this exhibit and the prior filing years, and would it be fair to say that? And can you explain? Can you please tell us whether the respondent ever filed timely before we issued the ACL complaint?
Thanks, Ken. Now, it appears that, you know, oftentimes the date we receive the report is between July and August of each year. While it looks like the respondent does file annually, it appears to be late most years except for this water year, which it appears to have been submitted in March.
Okay.
So yes, I would say that in almost all years, the annual report has been submitted late.
Okay, thank you. That was all I wanted to ask.
Okay, and then Mr. Petroselli, just to clarify though, the prosecution team is not seeking penalties for any of the earlier years late filings, but you just
No.
wanted that to go as to be evidence for consideration.
Yes.
All right. All right. Well, with that, we will shift over to Ms. Schaefer then. And Ms. Schaefer, do you have any questions for Mr. Cervantes? And you know, as a reminder, please unmute so we can hear you.
I really don't have any questions. The only one, you added up how many hours to comply, and you said something like 286 man hours. Is that just for my case, or is that for all the failure to file?
Good question, Ms. Schaefer. That's for the failure to file program in sum. So no, it's not for your case in particular.
Okay. That's really the only question I had.
Okay, that's certainly an important clarification. I'm going to just make a note of that. Thank you. Okay, so Mr. Cervantes, I do have some questions for you. And I'll ask Nicole if she can put up exhibit PT9, which is your declaration. Okay, good. And then if you can just scroll down on that first page, or first you're gonna go full screen, I assume. Yeah, there we go. So and this is a little hard to read, Mr. Cervantes, but I assume you have a copy of this and obviously you wrote this. So, but let me know if you need to expand it. We're still trying to fit it on the screen and yet have it be legible. But in paragraph 2 there, it looks like about line 27 and a half, it says you were have been the supervising water resource control engineer since 2016, but when you were testifying a few minutes ago, I think you said you were in your current position for 10 months. So I just wondered if you could clarify whether you were promoted into the supervisor position sometime after 2016.
I was. That is an error. Yes, I've been the program manager, the supervising engineer for 10 months. I've been a water resource control engineer with the Division of Water Rights since 2016.
Okay, and this testimony, this paragraph refers to the enforcement section.
Yes.
Were you in the enforcement section all the time since 2016?
Yeah, for the most part, I spent 2 years in cannabis registrations, but all with the Division of Water Rights.
Okay. And then if we can go on to page 2 of the same exhibit PT9. And again, it's if we need to expand it, please go ahead. But my question is on, you have a sentence on at lines 19 to 20, which says for a licensee, failure to file a licensee report is a violation of license terms. And I think you mentioned that during your direct testimony as well, that you said that failure to file an annual report was a violation of the license terms. But I went to the eRIMS and just downloaded the license for Timberlake Estates. It's license 7716. And I will add this to the record. You know, it doesn't have to be one of your exhibits, but just part of the record. But I didn't see anything in the license itself where there was any term requiring an annual report. And I just wondered if I'm missing something there.
You know, I'm going to need a moment to find where that term is, or in what portion of the license that filing a report is a requirement. If I may, please have a moment.
Okay, do you have that convenient? Because if not, we can try to arrange to get it posted if you need to. But if you have the license convenient, that might be the quickest way to do that.
Okay, no, I don't have the license in front of me, unfortunately.
Okay. I'm just wondering what the easiest way is to do that. I'll tell you what, let me ask my other questions. And then this is a little pedestrian, but I'll propose we just take a quick break and I'll email you and Ms. Schaefer and Mr. Petrozelli and Mr. Lewis a copy of the license, which I downloaded from eRIMS earlier today. And then you can look at that and then we'll come back after the break. I'm sure there's a more efficient way to do that. And as I'm talking, Kyle and Skylar may be working on that. So we'll see if they can come up with something quicker, but otherwise we'll just do it that way. But let me just go on with my questions for now. So Nicole, can you go to page 3 of this exhibit, PT9? But my next question is, I was reading this morning, that on line 3, it says the water code and applicable regulations provide notice of the requirement to file an annual report. I'm aware of that requirement in the regulations, but I'm not aware of any water code section that actually requires that. I wondered if you had a particular water code section in mind for that.
No, I believe you have found another error. It is the Code of Regulations.
Okay, and you have cited those, so I'm familiar with those. Okay, my next question is in paragraph 6, down the very last sentence, it's about line 18. It says division staff tweeted 7 separate reminders, and there's a true and correct copy of the tweets. It's exhibit PT2, and you referred to those today. And I have to say, I'm not super sophisticated with tweets, but do you have any information as to whether Ms. Schaefer or anyone else from Timberlake Homeowners Association received any of those tweets?
I can tell you I didn't. I don't do Twitter. I have an account I don't even know how to use.
Okay, and that's fine, Ms. Schaefer. I was going to ask you that question when you testify, so remind me if I forget, and you can say that. I want you to wait to say it after I've given you the oath, so we definitely have your sworn testimony. But so Mr. Cervantes, I mean, I understand you have thousands of people you're trying to get the message out to, but I was just wondering, do you have any way to know who's getting the message and who's not?
Not through tweets, not unless we look through all of the only way to verify that in a tweet is to see if a person has clicked the like button. But if someone has simply viewed it and continued to scroll in their Twitter feed, we wouldn't be able to confirm if they saw the tweet or not.
Okay, so I understand that's part of your overall efforts, but it's not, there's no guarantee of notice in a specific case from the tweet.
Right. Yeah, that's just one of multiple ways that we conduct public outreach.
Okay. All right, I'm going to go on down to page, or ask Nicole to go to page 7. And then I have a question on paragraph 20 on page 7. And again, it's a little hard to read, but the first sentence, I'll read it out loud. It says on July 7, 2019, the diverter filed their deficient annual report. As such, Diverter ultimately filed the requisite report 462 days after the deadline, after significant effort to compel compliance with the applicable regulation. And when you were testifying today, you said 98 days. I think the difference is about 365 days there. And I just wondered if you could clarify. I think that the report by your testimony was 98 days late, not 462 days late. But I wanted to make sure I'm not missing anything there.
No, I think that it was 97 days.
Or 97, okay, excuse
Yeah,
me.
97.
Okay, so I think if you do 462 minus 97, you get about 365. So that, I assume that was just added a year by mistake to get that 462.
That's how it appears, yes.
Okay. And then on next page, page 8 of your exhibit PT9, the paragraph 22, I'm just going to, it talks about the basis for the proposed penalty of $2,000. And starting at line 9, it says the division believes the proposed penalty is the minimum amount suitable to deter future noncompliance, while taking into account the resources spent by the State Water Board staff compelling the diverter to file the requisite annual report. And you've explained what efforts the division had to do, certainly very substantial. And as you explained in response to Ms. Schaefer's question, the 276 hours was for all reports, not just hers. But my question is, the factors that are listed in Water Code section 1055.3, there are various factors which you covered in detail, which I appreciate in your direct testimony through, and you had a slide on that, but I didn't see anything or don't see anything in the statute that specifically talks about that in considering the amount of the penalty that I am supposed to consider the resources spent by the State Water Board staff. And I just wondered if you could clarify that and let me know if I'm missing anything there. Because obviously I do have to follow the statute for the factors. And I know it does say in other relevant circumstances, but I just wondered whether you had any other comments on that.
So Mr. Lilly, I'm not sure I understood your initial question.
My question is, of the specific factors that are listed in Water Code 1055.3 for determining the amount of civil penalty, is amount of resources spent by the State Water Board staff a factor that's to be considered?
Staff costs are considered, yes, they should be.
Well, I understand that you want me to, but can you tell me what in the statute allows me to do that?
Okay, I understand. I need to think about that. So, right off the cuff, I believe that in order for enforcement to be a deterrent for the regulated community, at a minimum, we need to recover our staff costs, and board decisions in the past have indicated that, at a minimum, staff costs should be recovered regardless of what the additional penalty is. So that's mainly one of the main factors we used in naming that.
Okay, I appreciate that clarification.
If I may, Mr. Lilly, going back to the number of days, so I have a clarification for you. So,
okay.
The respondent filed their report 97 days after we issued the ACL, which happens to be 462 days after the date it was due. So there's a time in between the due date and the date that we issued the ACL.
Oh, wait a second. I'm very confused now. First of all, we're talking about the reports for diversions during 2018. Is that correct?
Yes.
So that the report was due on April 1 of 2019. Is that correct? I mean, obviously, it's the April
Yes,
1 of the year
yes,
after the year
yes.
when the diversions actually occurred.
Yes. Yeah, you're right.
Jump in
Okay.
and help kind of explain the discrepancy between the oral testimony and the written testimony.
I'm sorry, Mr. Lewis, are you asking a question or stating an objection?
No, can I please explain the discrepancy between the days in the oral presentation and the written declaration?
Okay, well, I'd rather Mr. Cervantes explain it since he's the person who's under oath here.
Okay.
But if he can't, then maybe I can have you do that in closing argument. But Mr. Cervantes, can you explain the discrepancy? It is your testimony after all.
Right. No, I hear you. I would like to defer to Patrick in closing arguments.
Okay, so Mr. Lewis, I'm sorry, I just don't really want you to testify on that point, but you will have a chance in arguments, which, is the time to clarify evidence. So if you can make a note, I certainly won't forget that, but I'd rather you do it at that point if we can do it that way.
No, thank you, Mr. Lilly. I appreciate the opportunity.
All right, thank you. So then I just had a couple more questions, Mr. Cervantes, and I do appreciate your taking the time on this. This is obviously very important, and your
Mr.
detailed
Lilly?
testimony is helpful. Excuse me, Mr. Petrozelli.
This is not testimony. It's a point of law, and perhaps I may direct you to Title 23 in the regulations, Section 929. And the last sentence of paragraph B states that a failure to file a licensee report shall constitute a failure to comply with the terms of the license.
Okay, yeah, and I appreciate that. And again, if you can make a note and put that into the closing argument, that would be great.
Okay.
It's a point of law, and it certainly is very appropriate for you to make, but I'd rather you do that during your closing argument. So, okay, so Mr. Cervantes, during your testimony, you referred to a June 12 warning letter, which was exhibit PT6. And my question on that was, is there any notice, did the water board send that by certified mail, or is there any way to know whether or not the respondent received that letter?
I do not believe we sent that notification by certified mail.
Okay, and do you keep records? I know we, in the Administrative Hearings Office, we send out first-class mail, non-certified, and sometimes we get things sent back by the post office because we have the wrong address for whatever reason. Do you keep any records to know whether or not that letter to Timberlake Homeowners Association was returned?
We do keep records of return mail, and we did not receive one for this particular respondent.
Okay, so you're pretty confident that it was mailed to Timberlake and that you did not receive a bounce back of the envelope?
Yes.
Okay. All right, and then my last question, I appreciate your bearing with me on this. You said in your direct testimony that the respondent rejected the $500 settlement offer, and it wasn't clear to me whether rejected meant just that there was no response or whether there was an affirmative statement from respondent saying we reject the offer.
Right, that's a good question. We consider non-response a rejection.
Okay, so that's what it was here, no response.
Yes.
All right.
Mr. Lilly, if your questions have created questions that I want to ask, do I have to wait till I testify?
No. I was just your timing is very good. I have finished my questions, and I will allow essentially redirect. So I will start with you, Ms. Schaefer, and then we'll wrap up with either Mr. Lewis or Mr. Petrozelli if they have any final questions for Mr. Cervantes. These questions should all be limited to what's been raised in the questions that have been presented today. I don't really want to go into new topics, but if you think I've raised an issue that you'd like to ask him clarifying questions on, now is the time, and please go ahead.
So the statement, Mr. Cervantes, that I rejected the offer of the settlement, I think is an incorrect presentation. I requested a hearing, which I'll testify my explanation for why I requested a hearing when I testify, but I was told my only way to have a discussion was to request a hearing. So I guess by default, I rejected because I requested a hearing. I did not reject the settlement offer.
Okay,
Does that make sense?
no, Ms. Schaefer, you'll get a chance to testify. That right now, though, do you have any questions for Mr.
Well,
Servat?
I'm wondering if they can tell me for the signature date on the ACL was sent by certified mail, the July 1st letter, and if they have the signature date on that.
Okay, so is your question for Mr. Cervantes, do they have a date when that certified mail card was signed and then sent back to the
Yes,
division?
because I can narrow it to 2 days, but I can't tell you which day.
All right, I don't know, Mr. Cervantes, do you have, that's not in the exhibits that have been filed, but do you have that information in a file where you can give us the date?
I believe we have that information in the file. I don't have it on hand though. It's in the file room.
Okay, well,
For certified mail, we keep the green return receipts.
okay, but you don't have that accessible today.
Mr.
No.
Lilly, I can refresh my client's recollection on that matter.
All right, let me just finish, see if Ms. Schaefer's
Okay.
done with her questions, and then we'll shift over to you, Mr. Petrozelli. So any other questions for you, Ms. Schaefer, of Mr. Cervantes?
No.
All right, so Mr. Petrozelli, we shift over to you. You may now ask follow-up questions, obviously limited to the scope of what's been discussed here on the cross-examination and redirect.
Okay, so Mr. Cervantes, first of all, California Water Code Section 1055.3, it requires the board to, in issuing an ACL amount, to consider specifically several circumstances, the amount of harm, the length of time the violation occurred, the nature and persistence of the violation, whether there were corrective actions, and all other relevant circumstances. Could you please explain first whether the staff costs is a relevant circumstance?
Absolutely. Staff cost is a relevant circumstance because I would say that less so if these types of batch orders and data review were simple, but oftentimes they're not, especially when reports are not filed in a timely manner. It forces us to have to pull data from our database and analyze what's come in and ensure that the data that has come in is correct, is usable. And so, yeah, I believe it is because it's a significant workload every year for folks that do not submit their annual reports.
Okay, thank you. Do we get on US Postal Service tracking, are we able to Mr. Lilly, can you bear with me a moment?
Yes, definitely.
Okay.
Just take a moment. I'll take a drink of water while you're thinking about it. Please go.
Yeah,
Please pause for a minute.
would it be possible to share my screen?
Well, I don't, probably not. I mean, it's,
Okay.
what do you want to put up? I'd like to keep this to exhibits that are in the record.
Okay, Mr. Cervantes said that he did not have the delivery immediately available. We do have that available, so I can, refresh his recollection. But the only way I'm aware to do that with this format is to share my screen.
Okay, and what document is it you want to show him?
It is the US Postal Service tracking that shows the date of delivery.
All right, what we can do, and again, this is a little tricky doing this all by teleconference, but that's the way we are. So if you want to put that up, we will label it as an exhibit. It'll be PT11. And then what I'll ask is, how many pages is it?
It is 2 pages.
Okay, So if you can put that up, we'll label it PT 11. That's an appropriate rebuttal exhibit. And then what I will ask you to do is after the hearing, if you can upload that to our AHO FTP site, the FTP2 site. But also, since it's probably a pretty small file, just email it to the Administrative Hearings Office email and a copy to Ms. Schaefer so that we have that. But with that, if that's, I'll ask Nicole, is there a way to let Mr. Petrozelli have the screen to put this up? Well, I think she's going to try, so we'll see if we can do that. So bear with us and we'll try to share that with you, and that will be for exhibit PT 11.
Okay, so Mr. Cervantes, do you see the document?
Yes, I do.
Okay, can you please explain what this is and what it shows?
All right. So this looks like it is a screenshot from the United States Postal Service's webpage that tracks certified mail. And it appears that this letter or this package was signed for on July 8th, 2019 at 9:41 a.m.
Okay, any other questions about this exhibit, Mr. Petrozelli?
No.
All right, and as I say, we will label this as exhibit PT 11, and it'll be part of the record. We'll talk in a minute about offering exhibits into evidence, but do you have any follow-up, any additional questions for Mr. Cervantes?
I don't think so.
Okay, well, just, you can take a minute
And I want to, let me stop the screen share. Okay.
Okay, while you're thinking about that, I'm going to see, I think my staff may have found the license from eRIMS. And if so, I'll ask Nicole to put that up. I'm not sure. We're all working from our respective homes, so it's a little tricky. But if per chance she has that and can put that up.
Actually, there is a question I would like to ask Mr. Cervantes about the license.
Okay, about the license.
Yes, since we're putting it up, there's.
Well, I think we're going to put it up if
Okay.
we've got it. So bear with me and I will ask us if we're going to do that. There we go. So
Okay.
license, and just for the record, and we'll just put this in with its date in our record. It's dated April 6, 1966, 2 pages long. It's water right license 7716, issued on application 17108. So we will add that with our background documents. They don't have exhibit numbers, but they are part of the record. So with that, why don't you go ahead, Mr. Petrozelli, and you can ask Mr. Cervantes whatever questions you want. And if we need to, we'll make the print a little bigger so we can read it better.
So yes, certainly. So Mr. Cervantes, I'd like to direct your attention to the bottom of page 1. And could you please tell us if the license says anything about the requirement to promptly file reports? And if we need to blow it up for you, please say so. And you're on mute.
Yeah, we'll see if we can scroll down and magnify. I don't know if we can, but we'll try. You have to have really good eyes to be able to see that.
Report, yes, in the second paragraph. Reports shall be filed promptly by licensee on appropriate forms, which will be provided for the purpose, and I can't read the rest of that line, by the State Water Resources Control Board. So that would be our online system.
Okay, it actually says State Water Rights Board, but that was the predecessor of the State Water Resources Control Board. All right, so Mr. Cervantes, it's your view, that's the license term that requires the annual reports.
Yes.
All right, thank you for that clarification, and thank you, Mr. Petrozelli. So we're getting through there. Do you have any other questions for Mr. Cervantes, Mr. Petrozelli?
I do not.
Okay. And then we're shifting back. We're going to wrap this up pretty quickly, but Ms. Schaefer, do you have any further questions for Mr. Cervantes?
No, I do not.
Okay, I do have two, just following up on what was just said. And we are going around and around, but I think we're almost done. So Mr. Cervantes, you mentioned 276 hours of Division of Water Rights staff time for the entire program. And to turn that into dollars, is there any kind of hourly rate? I realize it's a lot of different people at different rates, but do you have any kind of a composite average hourly rate that you can put to that, so I know what kind of dollars we're talking about for 276 hours?
Oh, that's a great question. So offhand, I don't know what the aggregate rate is, but I know that currently the regional board uses $300 an hour as an aggregate, something along those lines, $300 an hour, and that averages in supervisory time, like management time and admin time. So it's an aggregate number. And so 286 hours we use, or we spent last year for the administration of the failure to file program.
Okay, I wrote down 276, but
280, I believe it was 286.
Okay, I'm sorry if I wrote down the wrong number, but
Yeah. Close.
So you don't have an average hourly rate for the Division of Water Rights, but you're saying you think it's similar to that?
You know, we do. I just don't have it offhand. But when we calculate penalties, we have an hourly rate for each staff that touches the project.
Okay, and then the other question I have is, do you have any way to determine how many of those hours were spent on this matter, the Timberlake Estates Homeowners Association matter?
We would need to dig more closely into it to determine an exact number of hours, but I'm sure we could.
Well, I mean, it's now or never, basically, because we're going to close the hearing record today. So,
Okay.
can you tell us today whether you have any estimate of those hours?
So, including preparing for this hearing, would you consider that as?
Well, I think you should tell me what you think, and if you can split it up into different categories, that's better. So, as much detail as you can provide me would be helpful.
Okay, so let's say for generating the data itself, if we were to pull out Ms. Schaefer's information, I hesitate to answer because it's right off the cuff, because I need a moment to think about it. Is
Okay.
it okay if I take a moment to
Yeah,
gather my thoughts?
if you don't know, that's fine. But if you want to take a break, that's fine. We can just pause for a few minutes. Believe me, I don't dare turn this off, but we'll just pause and take a moment, and we'll just all stand by while you're thinking about it.
Okay, great. I'd like to take a break then and gather my thoughts.
Okay.
Or take a break.
Okay, we'll take a break for, let's say, 5 minutes, and then it's 2:10. We'll come back at 2:15.
Excellent. Thank you.
Okay, Mr. Cervantes, are you ready to proceed? And I don't want to take an inordinate amount of time on this. It was just a question I was hoping you'd know the answer to.
Yeah, right. No, and it's a great question, Mr. Lilly. So most importantly, I want to state that, we believe that $2,000 is an appropriate amount, and it's the lowest penalty that we can ask for that still makes the $500 expedited settlement agreement appealing. So that's one of the ways we ended up at 2,000. Now for staff costs, excluding attorney costs, just our staff, myself and Julie, we would say that we're at about 40 hours right now.
And that's the total through right now. So,
Well, that's yes, total up to right now.
okay. Can you split that up into amount that you spent to, and if you can't, just tell me. It's all right. But if you can you clarify how much of that was up to the issuing the ACL
Actually, I'm sorry.
complaint?
So let me clarify. So it was, I say 40 hours. I meant to say like it was about 40 hours pre-hearing, for pre-hearing costs. Once we received the hearing request, I would say that it would be a minimum of 100, possibly up to 150 hours of preparing for this hearing. So all said and done, I feel like we're closer to 200 hours total, mostly for hearing prep.
Okay,
I'd
so
say
you're
about
saying
40 hours of pre-hearing. So that's pulling the data, analyzing the data, preparing letters, and correspondence.
okay, so up to the issuance of the ACL complaint, you're saying 40 hours and then 150 hours from then until now.
Yes, approximately.
Okay. All right, well, I think we've probably wrapped this up as well as we need to for today, but I will just say, Ms. Schaefer, we've covered a lot. I do want to give you one final chance to ask any questions if there's any follow-up. I think we've covered it all, so don't feel like you have to, but if you have any other questions that you think are necessary for clarification, I'm going to give you a chance to ask them now. You have to go off mute, though. There you go.
I don't have any.
All right. All right, let's talk about exhibits, Mr. Petrozelli. We had exhibits PT1 through PT10 were posted on our FTP site. We've talked about exhibit PT11 today, which is the USPS delivery report. Would you like to offer those exhibits into evidence? You have to go off mute too.
Yes, we would. And I can email PT11 when we finish.
All right, send it to the Administrative Hearings Office email, and please send the CC to Ms. Schaefer.
Yes, yes, sir.
And if you just email it, we'll take care of posting it. I don't think it'll be too many megabytes. And just a clarification, the exhibit identification index that you filed in this matter had the application, water right license number, application number, and name for Brent Owen, but obviously it was intended to be for Timberlake Estates, and we will treat it as such. Ms. Schaefer, do you have any objections to any of these exhibits being received into evidence? And yeah.
No, the only one you're adding is the postal one, right?
Yes, the others were all posted before.
Correct. No, I'm fine with that.
Okay.
Glad to
All
see
right.
the other one posted.
Well, yeah, we had it up on the screen, so she had a chance to see that before. So I will go ahead and admit into evidence exhibits PT1 through PT11. And with that, we'll proceed to Ms. Schaefer. And first of all, I need to give you the oath before you start testifying. So Ms. Schaefer, do you swear or affirm under penalty of perjury that the testimony you will be giving in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And do you have any exhibits you would like to submit today, or is it just going to be oral testimony?
It's really just going to be oral testimony. I did not feel, when you hear my testimony, I think you'll understand why there really is nothing to submit.
Okay, so and I was just gonna say that's fine. I just wanted to make sure we mechanically would put up paper exhibits if you had any, but you don't have to. So please proceed with your testimony.
Okay. Timberlake Estates is a small association. We have 19 parcels. We have a volunteer board of which I'm one of 3 members. I serve as the treasurer and the secretary of the association. I became the agent of record by default when Ken Hall died suddenly. And basically his wife, his widow, just named me as the person to become the agent of record for the water rights. Due to his death, there was no pass off of information, no education. And basically I didn't have a clue what I was required of me, not until only, I was trying to dig and see if I could find the email, but I think it's on an old laptop. I did not even have a copy of our license or anything related to the water rights until somebody from the water board gave it to me, I think, maybe 3 years ago. Basically, I've had to learn this job on the fly. The primary purpose of our association is road maintenance. We're a small group of homeowners with a private road. And so we collect a small amount of dues every year, gather that money so that every several years we can resurface or do major repairs to the road. We have a few ongoing expenses. One is the water rates fee that we pay every year. We do maintain a general liability policy in case somebody were to crash on the road and try to sue the association. And we maintain a snowplow fund, a contingency fund. So basically we net about $3,000 a year that can go toward road maintenance fees, which run in the $20,000 to $25,000+ to do the road. So that's really the purpose of our association. The pond, and I'm going to call it the pond because that's what we all call it, that is a part of our association, just became, it was something the water rights were applied for before the association existed. And then in 1981, someone created this subdivision. And when they created the subdivision, that pond was incorporated, was a part of the land that became Timberlake Estates. So the purpose, the pond has really served it's a rain, it catches rain and it's pretty to look at and it provides some wildlife. That's basically what it is for us. We don't have any way to stop collection of the water other than we would have to tear down the dam, which is actually something that's been a topic of conversation in our association, but the costs associated with trying to restore the land back to the original cost for homeowners, and getting 19 homeowners to agree on something like that would take an act of, I don't know what. So basically the water comes in through a tributary, a creek, an unnamed creek that only flows when it rains. The man-made dam that was put in the 1960s dams the water, and then there's a spillway. When the water reaches a certain level, it naturally has to spill. And one comment I would make is that, the original application was for 11.38 acres. The license was granted for 12 acre-feet. We've had conversation amongst ourselves, and I've even had it with staff from the State Water Rights Board, about the fact that there's probably so much silt in that pond that we no longer even divert over 10 acre-feet, but the costs associated with proving how many acre-feet our pond can even hold are probably cost prohibitive. Again, like I said, the purpose of this pond is nothing more than, it's a pretty thing to look at a few months out of the year. And this year, I think it had water in it for 2.5, 3 months. It's bone dry right now. It was bone dry until almost April of this year. It spilled for exactly 1 day, because again, this is all just based on whatever the rainfall year is. My biggest struggle is that as a lay person, I really have had to learn just through online education, through talking to your people at the State Water Board. They have been amazing because this is totally not in my wheelhouse. I've even had them create a reverse curve for me to help me figure out and give me the calculation to figure out how much water is going into and being diverted in this pond. The regulations keep getting stricter. Right now, we have a staff gauge because we were forced, 2 or 3 years ago to have a formal way to measure. Before of that, it was eyeball it, and I jot it down on a piece of paper. Now we have a staff gauge, but still the bottom of that pond is not even. The perimeter of the pond, it's not a round pond. It is a very irregular shaped area. So it's beyond my ability to really do anything other than do the best I can with the measurements that were given to me, and now look at the staff gauge and just look at what the differences are month to month. And that's what they told me, is measure it once a month. When it's got water in it, I jot it down even more often than that. I might look at it weekly. I take pictures with my phone. I keep a little Excel spreadsheet of what the reading is on the staff gauge. So it has not been, this is probably my least favorite thing that I do. And unfortunately for me, when it began to become more of a challenge, I had something happen in my personal life, which I did mention in my hearing request. My husband in 2017 was diagnosed with a GI bleed, which we still are battling today. And it has resulted in many, many days in the hospital. It's over 80 days. He's had over 75 units of blood. And unfortunately, it happens on a heartbeat. We never know where we're going to be day to day. So when this 2018 year was happening, my husband spent 40 days in the hospital between March 24th and July 4th. And I was receiving notices, never received a Twitter because like I said, I have an account. I don't really even know how to use it. And I certainly never followed the water board. But I did receive the notices. Whether they were opened on time, I know that I have read the June 12th email. 2 of his hospitalizations in that 40 days were 12 days. And I would mention that my biggest challenge is that he can't be cared for locally. Most of the time we end up in San Francisco. And in fact, when that July 1st deadline came around, we were sitting in a hospital in San Francisco, and I stay with him in San Francisco when we're there because it's a 3-hour drive from my home to San Francisco. So I was very aware of the July 1st drop dead deadline. I had that heart sinking feeling being in a hospital in San Francisco, and there was nothing I could do. So we returned home on the night of July 4th, got settled, and on Sunday, July 7th, I filed the 2018 report prior to even seeing the ACL. I knew I was late, but I was just hoping, I'd already filed it. My husband and we went to the post office on Monday after I'd already filed the report on Sunday, and that's when I saw the ACL notice. So it did arrive at our post office, but it didn't get into my hands until Monday the 8th, which was the day after I'd already filed. So that ACL is not what prompted me to file. I knew that I needed to file, but I had a lot on my plate. I haven't mentioned I work full-time and commute. Prior to COVID, I commuted 2 hours a day, work full-time, and I'm a volunteer, and I care for my husband. So life being what it is, I filed on the 7th. When I got the letter, I immediately called the number and I said, is there anything I can do? I've already filed, I've already met the requirement for the filing, but now, my goodness, I've read this letter and I'm heart sick. What can we do? And basically what they told me was the only thing you can do is request a hearing. There is no, you can't, I said, can I write a letter? Nope, you can request a hearing, but they were super encouraging for me to write a hearing. Request a hearing. Their comment was that all enforcement would stop and the hearing would happen, and if anything, it wouldn't get any worse than it was. Well, my interpretation of it wouldn't get any worse is it wouldn't get any worse than the $500. Not that you would go back to enforcing the penalty, or else I probably would have just settled. But I chose not to settle because I really did want to plead my case that there are some extenuating circumstances. And unfortunately, I'm the only one in the association. We have very few, most of our members come to a barbecue once a year. We don't this is not a normal association that has regular meetings or active people. We have a work party a couple times a year to trim weeds back on the road. We have a barbecue once a year. So there are people to hand this off to. And when I realized I was in the serious jam of not being able to meet the July 1st deadline, my paperwork's in my home 3 hours away and nobody else has ever touched it. There's no way in the world I can talk somebody through doing what needed to be done with me not beside them and handing, guiding them through what would need to be done. I don't want, yes, there's been a history of late filings because, as I've said, this is the thing I struggle with. I feel like I finally understand it well enough, and I did file on time this year. I don't want my failure to file to be construed as a disrespect for the request, a disrespect for the need to do this. I fully understand that it's important, but I do also think that, I wish that I could have just written a letter and we wouldn't have had to get to this level of a hearing, because it's a waste of everybody's time. One of my things I really want to say is that whatever the penalty is, I'm going to be writing the check out of my checkbook, because I will not ask the association to pay for my mistake. So really, there's not a lot else to say.
Okay, if you want to take a minute before we conclude, Ms. Schaefer, I'm certainly happy to take a break for a few minutes if you would like to.
I'm sorry, I wasn't going to cry.
No, this is very important, and this is your opportunity for a hearing, and I want to make sure you have an opportunity to say everything that you think is important. So it's by my clock, 2:33. I'm going to just say, let's take a 5-minute break. We're going to leave we're certainly going to leave the Zoom meeting on, but let's just come back again, just 5 minutes, 2:38, and then you can think about whether there's anything else you want to say, and then Mr. Petrozelli will be able to ask you our cross-examination question. So again, 5 minutes, back at 2:38. Whatever you do, nobody log off, but we'll just go on pause for that. Thank you.
Thank you.
Okay, we're back. I remembered to unmute, and it looks like we're ready to go. So Ms. Schaefer, is there anything else you would like to say? You don't have to, but I wanted to give you a minute just to think about if there's anything else you'd like to say right now.
Basically, had my husband been in a Sacramento hospital where I was coming home even after a 15-hour day, but still coming home at night, I would have been able to file on time. Unfortunately, because that hospital stay was occurring in San Francisco, I know that I had read the June 12th letter. I don't know what day I read it, but I had the July 1st deadline in my mind. But unfortunately, I was not in a physical place where I could do what I needed to do. But the minute that we got home and things were stable enough for me to do it, the report was filed. And it was filed, as I said, prior to receiving the ACL. That wasn't the motivating factor. You know, I mean, the threat of June 12th was motivating to me to do it and knowing that I needed to do it. But I unfortunately have not been able to juggle my job, my volunteer duties, and my husband's health. And unfortunately, his health has to come above my volunteer duties. So, you know, his condition is extremely volatile. We never know. We spent the whole Christmas in the hospital. So from December 23rd until the 28th or 29th, we were in the hospital again. So unfortunately, you know, I joke with my family and friends that I make plans and everything in our life is subject to change. So
Okay.
that's about it.
Okay, thank you. I think you've made your position very clear, and I certainly appreciate that. So, Mr. Petrozelli, do you have any cross-examination questions for Ms. Schaefer?
I do. Ms. Schaefer, about how long have you been the agent for the water right?
It goes back to 2011, but I didn't do anything with it for the first few years at all. I mean, somebody just put me on a postcard to be the person, but I had zero knowledge.
But you were the agent for the water right?
Yes, by the death
And-
of a neighbor. So the
about
neighbor
how-
that Ken Hall was the agent of record. And when he died, his widow, because I was the treasurer, just wrote my name down and had me put as the person. She didn't ask me. I was just made that.
But so about how many years was that?
So
Has that been?
it's been about 8 or 9 years.
So about 8 or 9 years, and about, you know,
That
if this-
probably didn't touch anything associated with the job. I'm going to say until 2016, when it became apparent I had to figure out what the heck I was doing because I had no clue. I got
And-
nothing handed to me.
And did you start filing reports at that point?
Yes, but you can see that they were filed, like at that point, there were mass filings and then trying to figure it out. And then the form, you know, I truly struggled. I know in the beginning, I did not even understand what I was doing. I look back at my early reports. I always accounted for 12 acre feet because I would know that the pond at some point filled up and at some point it emptied. And since it's the way it's designed, it can never gather more than the number of feet that, you know, based on the spillway design. So, but I just would divide it out by the rainfall. And then they started explaining to me, no, you have to, you know, figure out when it hits here. So over the years, I've learned a little more and a little more. I still don't feel super thrilled about the job, but I understand it now.
Thank you. But you did file reports before this.
Yes, but I would tell you my early reports were probably not, they weren't right. You know, the footage was right, but not the way I calculated monthly.
But they were filed.
Yes.
Okay, so they were filed. So you knew how to file the reports. Would that be correct?
Yes. I don't discount for 1 second that I know how to do it. What I'm saying is that honestly, it's just something that's doesn't come second nature to me, doesn't come easy. And if there's a lot else, that's basically this year where you guys became very serious about the deadline. And unfortunately, my life circumstances prevented me from accommodating and, you know, meeting that deadline because that spring was a very rough year.
Thank you. And I believe you testified about receiving a notice by email. Would that be correct?
I've seen emails this year. I testified to receiving the June 12th letter, but I don't know when I opened it.
Okay, but you testified about receiving email reminders.
I've seen emails this year.
Okay, and I believe you did you indicate in your testimony that you received, I believe you indicated in your testimony that you received reminders by email to file this report.
This one, the
Would that
only
be
thing
correct?
I got was the physical mail that I recall. I don't recall reading any emails related to that. No,
Not for this report.
not for the 2018, no. 2019,
don't-
even, and interestingly, even after I filed, I'm still getting reminders.
You don't recall receiving an email reminder on or about May 10
I,
to file a report?
no, if I may have, but I don't know. I mean, I have to say this was amidst, that's what I'm saying to you. This is amidst we're reading personal email. No, my personal email right now has 20,000 emails in it.
Okay.
So I could go back and is it there? Very possibly. Could I tell you I read it? No.
So was it also your testimony that your husband got sick on or around July 1?
July of 2017.
July of
been going-
2017.
This
Okay.
has been going on for nearly 3 years of my life.
On
This is not it's on again, off again, on again, off again, you know.
Okay. And this year, approximately, can you describe approximately when he was in the hospital?
I can tell you that in the spring, he was in the hospital on and off from April. It was 40 days between March 28th up until March 24th of 2019. There were 40 days of hospitalization between that and July 4th. And many of those were back-to-back transferred from one facility to another facility.
But he was not always in the hospital.
No,
Would that be?
no,
Okay.
I would not even try to, or I would tell you that there were very few days out, but
And if he went to the hospital on or around March 28th.
24th, yeah.
Excuse me, March 24th. There would have been an opportunity to file the report before then. Would that be correct?
Certainly. I would tell you that in between, what I didn't talk about is outpatient scopes, transfusions, procedures. We're at well above $2 million in medical bills in these 2.5 years. And in addition, I'm only counting inpatient hospital days. He has a team of doctors between Sacramento, Roseville, Auburn, and San Francisco. And so there are many days. So yes, I'm not going to say I couldn't have found a moment to do it. I'm just saying that in everything on my plate, no, I did not. And then I would have made the deadline because I would have moved heaven and earth to make that July 1st deadline if I wasn't completely out of commission from being in San Francisco.
Do you understand that the deadline for filing this report is April 1?
I do
of each
now.
year?
I do now, yes. And I'm going to tell you that in my head, it was July 1st was always when this came, I'm very clear that July 1st is a final. Yes, I do understand that.
Okay. And I believe you also testified that there are 3 members of the association board?
Yeah, but they don't do anything. There's one's an architectural one, and one is the president. And no, I haven't shared any of these duties with them.
Okay, but there are other members of the board.
Yeah.
Okay.
And this is where I say that I screwed it up. So now I'm going to be the one to fix it. Whatever that outcome is, I'll be the one to fix this. And do I think I need to find somebody else to know how to do it or find a way to make sure? I think this year I filed in March because I do understand, because it isn't lost on me, the importance of doing this. and doing it better and doing it right. So, yes.
So, Mr. Lilly, I think those are all my questions.
All right, thank you. So, Ms. Schaefer, I just, excuse me, let me get my notes here. I think you explained your situation very clearly and in a lot of detail, and I certainly appreciate understanding it. I do have a question. I'm going to ask Nicole to put up exhibit PT7 on the screen here. That's the, and you know, that's the, obviously you've talked about this. This is the July 1 letter. And I'll ask her to scroll down to, the pages aren't exactly numbered, but it's about the 7th page of the file, I think, 7th or 8th page of the file. Let's go to the 7th page of the file and see where we get. Okay, yeah, that's exhibit A is the settlement offer. So can you put that in full screen, please, Nicole? And then, I think, Ms. Schaefer, you explained that you understood this settlement offer and the ability to pay the $500, and that would basically take care of it. But you said you wanted to have a right to a hearing, which certainly you're entitled to, and this is the hearing that you're entitled to. It's taken us a while to get there, partly because my office had to be created by the legislature and we had to be up and running, but we're here now. So I guess my question for you is, the very last sentence on this page says, failure to accept the settlement offer within 20 days of receiving the ACL complaint shall render this settlement offer voidable and may subject diverter to the full proposed liability amount, $2,000 specified in the complaint. Do you remember reading that when you received this letter on July 8th?
You know, I remember vaguely reading this. I was so heartsick when I opened this letter, I can't even tell you. And since I had already filed the night before of my own accord, I immediately called and said, what can I do? I've already filed. Does that make this letter null and void because I've already filed? Because in my heart, I'm thinking I've already filed. The point of this filing, this complaint, is to get me to, to file, and I have done that. So to me, since the deficient report had been filed the night before opening the letter, that's why I reached out by phone and I said, what can I do? And said, I am just heartsick, and what are my options? And they basically told me, they encouraged me to file for a hearing. They said there is no way for you to write a letter explaining what happened. They basically said the only option was to file for a hearing. So they also said, because I said, is there any chance for forgiveness? Because I'm going to be writing this check, not my association. And they said, yes, there is a chance for that, but that would all happen as a part of the hearing. And they did tell me the time gap between when I requested the hearing and when it might occur would be lengthy. Although I have to say I was starting to get concerned that everything was lost in the mail, so to speak. But no, I was under the impression that by requesting the hearing, things weren't going to get worse. So I don't think that I did take that final statement into effect, because I wish I'd written down the name of the person I'd talked to and had a recording in the conversation, because they, were very empathetic to my circumstances and encouraged me to file a hearing.
Well, so and I understand you may not remember who you talked to, but did they mention anything at all about this settlement offer that's in this Exhibit A?
No. I read through the whole thing and just said, what are my options? What can I do? And they said, file an appeal, request a hearing. Okay, so they said you can request a hearing, but they did not say you can sign the settlement offer and pay $500 and be done. No, and in hindsight, I'm heartsick sitting here today.
No, believe me, I understand your personal circumstances, and I certainly have my condolences. That's a very difficult situation. Obviously, nobody would want to go through that.
If I understood then what I understand now, of course they would have settled for $500 and none of this grief.
Right. Okay, I don't have any other questions. So, Mr. Petrozelli, do you have any follow-up to my questions? And you have to go off mute if you want to talk.
Thank you. Thank you for reminding
We
me
all
to go
forget,
off-
including
go
I
off
just
mute.
did it a few minutes ago. So please go ahead.
In an abundance of caution, I'm accustomed to muting my microphone when I'm not talking in order to
That's fine. So do you
minimize
have any
the
questions
intrusion.
for Ms. Schaefer now?
Yes, I do. Ms. Schaefer, you indicated that you would pay this penalty out of your own pocket.
Yep.
Are you required to do that?
No, but I would never expect our tiny little association to write a check for that. I will require myself because it's a personal. I screwed up. I have not denied that from 1 minute. And I will be writing the check.
And I'd like to ask you another question. You indicated you received the June 12th letter.
Yes,
Okay. Did you have the same address in February?
yes,
Okay. So if the February letter was sent to the same address, then it would have gone to the address that you were at. Would that be correct?
yes.
Okay. Mr. Lilly, I believe that's all I have.
All right. So let me just check my notes here. There were no respondent exhibits, so we don't need to take care of those. So just to wrap things up, we do have time here for closing arguments and for the prosecution team by the attorneys and for Ms. Schaefer by you can make an argument. And you don't need to repeat what you've already said, but if you want to do a summary, that's fine. But we will start with Mr. Petrozelli. And again, don't feel like you need to go through a lot of detail because we've covered this all quite well, but I do want to give you a chance to make any closing arguments that you want to at this time.
Okay, thank you. Under Title 23, Section 929, Paragraph B of the Code of Regulations, a failure to file a licensee report is a violation of the license terms. The respondent's license further requires a prompt filing of reports. Thus, a failure to file a timely report constitutes both a violation of the license terms and of the regulation. The respondent was required to file the annual report, and this is not contested. Neither is it contested that the report was not timely filed. And this was despite extensive outreach and every reasonable effort by the division to encourage license holders to timely file their annual reports, and even further efforts to encourage them to file their reports even if late. The respondent, Ms. Schaefer, has indicated that she received notices. She's had the same address, and since we did not receive returned mail, it is reasonable to infer that those reminders by mail were received by her at her address. She talked about her husband's medical treatment, but the association has 3 members. She could have asked another member of the association to take on some of her responsibilities while she was having difficulties. And I will further point out that the respondent never filed a timely report until we issued this ACL complaint. She's been the agent for approximately 8 years before this report was due and therefore had a significant amount of time to understand the requirements that went with owning this water right. Although previous reports were filed late, they were nonetheless filed. So she understood how to file these reports. And as she said, she was aware of the deadline. These reports are important. The board cannot efficiently administer the state's water resources without timely information. And we need effective penalties in order to encourage water right holders to provide this information. We believe the $2,000 penalty is the minimum penalty that is effective for encouraging water right holders to timely file their reports. And thus we recommend the $2,000 penalty. Thank you.
All right, thank you, Mr. Petrozelli. So Ms. Schaefer, again, you have explained your situation very well in your testimony, and I understand it, but is there any closing argument you would like to make before we wrap up today?
No.
All right. Well, with that, then, I'm just going to check my notes here. Sorry. Just bear with me. Okay, so we're done for today. First of all, I want to thank everybody for being very professional, both the members of the prosecution team, Mr. Cervantes, Mr. Lewis, and Mr. Petrozelli, and then also respondent, Ms. Schaefer. I think everybody has done a very good job, and of course it's challenging to do this all remotely, but I certainly understood where both parties are coming from. I don't know where we on the Administrative Hearings Office are going to end up, but I think everyone has expressed their positions and their situations and the relevant facts very clearly. So thank you very much. And then also, I definitely want to thank my staff for managing to keep this hearing going, Nicole in particular for getting all the exhibits up very, very timely, and then the others for doing the backup to make sure everything was working well with the Zoom meeting. So we still are learning. We'll probably do some refinement for future hearings, but frankly, today went very well, and it couldn't have been done without their help. I certainly could have never done this without their help. So thank you to them very much. As I said before, under the water code, we are required to get our proposed order completed and transmitted to the water board within 90 days of today. It will be deemed submitted as today, and we will do that. And when the proposed order is transmitted to the board, we will certainly email copies directly to both of you and then post it on the water board, on the Administrative Hearings Office webpage, and send it to anyone else who is on our list for receiving emails. So with that, I'm going to wrap it up for today. Thank you all very much. I hope you have an enjoyable rest of the afternoon on Friday and an enjoyable weekend. So goodbye.
Thank you, Mr. Lilly.
Thank you.
Thank you all.